Manish sir, shall we start?
Yes, you can start.
Good afternoon, all. Welcome you all to the second session of workshop series on perspective on IBC. Today we have with us Manish Paliwal sir as speaker for taking session on IPs as enhancing multifaceted skills required under IBC as a IP as a lawyer. Let me briefly introduce sir. Sir is advocate on record in Supreme Court of India. He is a registered IP and fellow of CLARP. He has rich experience in dispute resolution, including mediation, arbitration, and litigation. He has a lot of experience regarding representation clients in both contentious and non-contentious cases in courts and tribunals across India, including Supreme Court, Delhi High Court, NCLT, and CLAT. He has lot of published judgments on wide range of topics. Since 2006, he has worked in area of arbitration, corporate law, bankruptcy and insolvency, banking, real estate, intellectual property, cyber law, administrative law, land acquisition, government contracts, consumer and competition law. Now over to you, sir. You can start it.
Thank you very much for introduction, and thank you very much, Ranjit ji, for keeping your camera on. That helps. You are the only one. I request.
Thank you, Manish.
Thank you.
Sure.
Singh Saab also, Arora ji and Prabhudayal ji. And I request all of you, Satyadevi ji and anybody else who can keep the camera on. It will help really. Suhas ji, thanks. Umesh ji. So basically, today's topic is something which cannot be put in the straight jacket formula. So I wish that all of you discuss and ask the real question which you face in day to day. I have gone through the list of the participants, and I assume there are very few lawyers. Most of you are either chartered accountant or company secretaries. And you people face the most of the difficulties in a different system so far, not so familiar, or you are accustomed to go there very regularly. So it's very difficult to formalize such a thing. So if any of you have a question at the beginning of the session, or do you want me to start like the way I wish to? Anyone, please.
Yes, sir. Good afternoon, sir. You may start with your own flow, and then as and when something is required, we will interact with you, sir.
Okay. So I'll just tell like my experiences, and it is all about experience sharing. So I am doing litigation since 2006. I'm an advocate on record in the Supreme Court and have gone from, I have practiced in all courts, right from Tehsildar, SDM to the district courts to high courts, consumer forum, tribunals, Supreme Court, NCLT and NCLAT. So whatever I'm discussing today is based upon the experience rather than any straight jacket formula prescribed by any law. I have qualified the examination for the IP as well. I'm representing the IPs as well, and I'm fighting few cases against the IPs as well. So to begin with, there is a kind of communication or information gap between the IPs and the advocates. Reason being the difference in the nature of practice. Most of the resolution professionals, not all of them, but most of the resolution professionals, before becoming IP, were either chartered accountant, company secretary, or cost accountant, or bankers. Few of them were advocates as well. And they cleared the exam and entered into the practice which is hybrid in the nature of their previous profession with as a practice of legal side plus management side. So typically a practice of a chartered accountant, company secretary and all those things is dependent upon the number of clients you acquire. and there is a periodical dates of the filing or compliances or giving the opinion, and you continue with that business or profession architecture, like how many companies you are servicing, etc. The practice as a lawyer is completely different. If you want to draw the analogy, it is something like a doctor. Reason being, most of the people who goes to the doctor not to do their health checkup, but they go there as and when they have some kind of difficulty. So it's not repetitive, it's not stereotype, and it's always in a challenging situation. Somebody has put some kind of accusation, then only the lawyers are invited. So this is the fundamental difference in contentious and non-contentious practices. So when we compare the other professions, for example, chartered accountant, company secretary, those are the most prevalent, or even a banker or cost accountant. Those are non-contentious practices in a way that if there is a fight, it is only regarding the payment of money with the government department most of the time. They are not fighting when there is a real fight between two private individuals or where the stakes are really colliding. So what difference does it make to the practice? The biggest difference it makes to the practice is that as a lawyer, most of the cases you get are not identical. One. Two, since the person has some kind of problem or wants something, so they ask the remedy as soon as possible. Again, drawing analogy from the doctors, if somebody has a fever, they want the remedy quickly. Similarly, they expect the system to deliver. But here is the catch. Unlike the system of the medicine or doctors, the entire infrastructure of the justice dispensation is heavily dependent upon the government support. So there are not enough judges. The judges are not enough, like well equipped, and the speed can't be guaranteed by a lawyer. Unless when you're going to the doctor, if there is a problem, they gives you the pill. But if you go to a judge, on an average, in any court, more than 50 cases are listed in a day. So it's humanly impossible for anyone sitting on that chair to apply judicial mind and go through those documents of each and every case. Coming back to the same thing, typically in the insolvency, the case file consists of more than 1,000 pages, accounts, etc., 1, 2, 3, many of the things. The judges normally are not trained in all the kind of commercial cases or all the kinds of industry which come up before them. As a human being, they have the limited time, limited resources. So they can't give the quick justice. So the first and foremost of the entire thing, the IBC came out with the thing that we will make sure that this time period, which is taken by a recovery or an insolvency to resolve, is to be curtailed. So the framers of the law thought that we will prescribe time frame. This much days, this much days, this much days. Entire IBC is full of T plus chart. So T plus so many days, T plus so many days. But when it comes to the actual implementation, the current system is not designed to handle so much of the caseload. Be that as it may, the IBC has proven way more efficient than what we had earlier, and therefore it gets. So relating back to the topic, the fundamental thing which as a IP or as a lawyer or as a lawyer as a IP or IP as a lawyer, one must keep in mind that it can't be a quick remedy when it comes to the bench or the NCLT or NCLAT, High Court or the Supreme Court. But when it comes to an IP, you are handling 1, 2, or 4 cases, whatever it may be. They will always expect you to perform in the timeline. When the timeline comes to the judiciary, they are always directory. And when the timeline comes to the IP, they are always mandatory, kind of thing. If the things are beyond the control, no, nothing can be. So this is the fundamental difference from the other systems. So the people have the always having the complaint, what is it? Second fundamental difference in the practice, other practices and the practice as a lawyer is the nature of the subject. The nature of the subject, since be it cost accountant, chartered accountant, company secretary, or any other profession, all of them have read the law. Everybody has read the taxation, etc., etc. Law is almost a compulsory subject in any of these streams. That doesn't mean that they got the things right. Why? Because practicing a law in a courtroom is like working in a laboratory. Why? Again, we come back to the same question. The reason is that if you are working in a corporate house or in that kind of setup, then the input and output is predictable. 2 plus 2 will be always be 4. Tax calculation, if the numbers are right, it will reach to a particular figure. And if there is anything else, there is subjectivity in that profession is very less. If form is to be filed in an MCA portal, there is hardly any subjectivity to it. So if there is an Excel sheet diagram, there is no subjectivity. But in law, one must understand it by heart that it is a subjective subject. So what is a subjective subject? Subjective subject is the thing when if a particular word is given to a person, the two people can have different of opinion on the same word. So one person might think that this is the meaning, the another person can think this is the meaning. And both of them might be right in their own way. So much so that one of the researchers at Geneva wrote a thesis of around 500 or more pages on the interpretation of the word or. How many ways it can be interpreted. So one person may be right, the other person can be right. It's all subjective. And to go with a mindset in the courtroom that what I feel is right may not be always the correct way of approaching the court. Because it might turn up that the other side or the judge will have a different understanding of the same thing. So let's taking an example. I'll take the example of say medical negligence, not related to IBC. I'll come to the IBC example next one. So one person says a patient who was there on the bed, it was on the operation table. The operation was conducted successfully, and after 5 minutes, he died. Only this much of the facts is given to two people. One person might come to a conclusion. This is 100% of proof that the operation was not done well. And that's why the person died. The another person in the same set of facts can come to the conclusion. Many of the things in this world are unpredictable. not under the control of any person. And therefore, there is no fault of the person who was operating because he has no interest in killing that person. Coming to the IBC, there are many cases where the IP is supposed to give judgments. Most of the cases are like the claim decisions, like the claims which they are supposed to collate and etc. There are disputes going on. Some person takes a view that this is the right approach. Take an example of before this delay period came in, they rejected because it was belatedly filed. The court says otherwise. So being a subjective subject, unlike the other professions, one must keep in mind that it's always relative. So in order to reduce this unpredictability, what is the method designed? Because law evolved over a period of hundreds of years. It was not the same. It is evolving day by day. The best example of IBC, it being an economic law, it is prone to more changes. Some of the things which were not clear, or rather were going on one direction or another, both the direction was correct. The law said that now this has to be corrected. So it has to be. So the entire lawmaking process is continuously evolving over the period of time. So they have a mechanism to reduce this unpredictability. This is like three-stage filtration process. Three-stage filtration process means that you have at least two forums to appeal. In case of a normal case, it's the civil court, high court, and the Supreme Court. In case of IBC, it's the NCLT, NCLAT, and the Supreme Court. So if somebody has taken a view in NCLT, right or wrong, it is again being tested in NCLAT at the appellate stage. And if it goes in the further appeal, it is retested at the level of the Supreme Court. Even the Supreme Court might be completely incorrect. But the Supreme Court is supreme because their opinion on this subjective subject is final. So one of the reasons why the Supreme Court is said Supreme Court is because they can put rest to the controversy rightly or wrongly. That's how it is supreme. So how this mechanism works? The mechanism works that whoever making a decision must follow the rules of natural justice. What is a natural justice? The first component of natural justice is notice. A party whose rights are going to be affected has to give the notice, has to be given notice. So you must have seen, this was a contentious issue in the personal insolvency cases. Irrespective of the court and the law, in all countries which is governed by rule of law, in all quasi-judicial and the judicial proceeding, the first and foremost and the fundamental principle of the natural justice is the person whose rights are going to be affected are given to the notice. So you have seen section 8, 9, 95, 96. The person whose rights are going to get affected is given a notice. This is the first principle. If the person knows that I have received the notice, then what he is supposed to do? He is supposed to appear before the court. So next component of this operating process of the law is person who has been given the notice is supposed to come before the court. How he come before the court? Two ways. One, he comes in person. Two, he comes through an advocate. All the people may not be available all the time. That's why after this I'll come how the advocate's profession has been developed. So it will give a fair idea that how it works. So he comes to the court through an advocate. The next thing he gets by presenting himself or subjecting himself to the law is the right to file the reply or put his contention before the court. This could be orally, it could be in writing, it could be any other mode which is permissible. Now the virtual hearings are quite prevalent thanks to the technology and forced social change brought by the COVID. So the right to be heard comes to the next. The right to be heard means, like so far we have seen the notice, the first party came before the court and says that he has defaulted. The defaulter came before the court and says that I haven't defaulted, these are the facts. So in between, the pleadings are completed. So most of the time, particularly those who have not practiced in the court of law, feels that a lot of time period is being wasted on such small dates. Every time a lawyer comes and says that, sir, I haven't received a copy. Please give me the date to file counter and rejoinder. And court gives it. And the person who is not familiar with the system says that, what is this? After every day, I'm getting a date of 15, 30 days or 2 months, 3 months just for this thing that he knows and I know what is the truth. Why the judge is taking so much of time? The reason is this is an important component to bring the truth before the court. Why? Because court does not know what actually transpired between the parties. So first party says that these are the facts. The second party gets an opportunity to contradict those facts. If there is new fact which has been brought in the counter, the first party again gets the file a rejoinder. So this pleadings rights continue till new facts keeps on emerging. Depending upon the facts of every case, the court grants the time to file rejoinder, counter, XII, and other pleadings. Normally, in a civil case, after a pleadings are completed, the next step is framing of the issues. And after framing of the issues, the matter goes into the stage of evidence to prove the documents or the facts which are asserted. And after completion of the evidence, cross-examination, all of you must have seen lots of movies in which some person is standing in the Katgara and other is interrogating him, the cross-examination, the famous thing. However, it is not conducted in the real life like that, but that's how the industry presents it. And after completion of the evidence, it goes for the final hearing. However, in IBC, since the scope of the inquiry is extremely limited at the stage of admission, there is no detailed evidence taking at all happening, be it in the case of personal insolvency, be it a case of a corporate insolvency. So that inquiry is limited whether there is any default or not. If there is a default beyond the threshold, earlier it was 1 lakh, now it is 1 crore. Just beyond the default, and even 1 rupee is more or at the limit, the court says default has been proved. They proceeds and decides the case accordingly. So, since the inquiry is less, there is no evidence stage, and matter comes to the final argument, which is the NCLT. Now, NCLT takes an opinion whether there is a default or not. This decision or any other decision of the NCLT can be taken for the next round by any of the parties to the NCLAT. Appeals can be filed. They are again tested on the touchstone of the IBC and decided. Why? Why we don't have the multiple stages in the NCLAT? 2 reasons. One, it's an appellate proceedings. So the records are available to the parties. So therefore, only pleadings are completed. There are no evidences in the appellate court, and that's how it is being decided. So I'll request you, all of you, so far, if any of you have any questions. So
this is the new thing, sir. This is the new thing which we heard, that the appellate in the appellate court, only the evidences are not put and only the pleadings are there. Can you explain this a little more, sir?
Right. Thank you, Singh sir, for your question. So in the appellate stage, even in NCLT, there is no proving of the documents. But at the stage of the NCLAT, and even in case of the normal civil case in the High Court, since both the parties have given their all the documents, all the evidences in the court below, so the court has the right, in case of High Court being a supervisory court, to call for the record. So the same task is not repeated again. So when you are drafting an appeal as a counsel, you are not supposed to do the exercise from ABC. What the court expects you on the first date of hearing is just point out what fault is committed by NCLT. So in case of any appellate forum, NCLAT, High Court, or any other tribunal, the first question which comes out from the mouth of a judge, that these are the records which you have filed, including yours and the opposite party along with your appeal. Based upon these records, a particular judgment has been given by the NCLT. Now, tell me where the NCLT has gone wrong. That's how the system is designed. There is no fresh evidence taking. It's on the parties pleading, the appeals are decided. And the next stage goes to the Supreme Court. So I hope I have answered question, Mr. Singh sir.
Yes, sir. Correct.
Thank you, sir. Thanks for the question. So next stage is Supreme Court. Supreme Court is unique and the most powerful court, not even in this country, but across the globe. Across the globe means we are comparing the powers of the Indian Supreme Court with any other Supreme Court. There is no other Supreme Court in the world who decide these many number of the cases in the world. There is no other Supreme Court in the world which has so wide a power or a custodian of the Constitution like an Indian Supreme Court is. So the Supreme Court in the constitutional architecture is the custodian of the Constitution. The Constitution is the fountain where every person derives its power, be it Prime Minister, be it President, be it a minister, be it a judges. All people in every kind of administrative or other hierarchies, in one way or another, derives their power from this document. And the Supreme Court has been given the responsibility to make sure that every other organ of the state, be it the police, tax department, government, prime minister, state government, follows that constitutional document. This is ensured by inserting 3 articles in the Constitution of India, which you often hear. This is the last stage of the filtration in the entire mechanism. One is Article 226, one is Article 32, one is Article 136. So the first two, 32 and 226, deals with the fundamental rights and other rights. In some cases, it's 226. And 136 is leave to appeal. So I'll explain quickly the differentiation and how you people or the people use them to get the justice in the Constitution, and how the IBC is little bit different as a practitioner or as a lawyer or whatever it may be. So first article says 32, if any fundamental right is violated, then any person in India can directly approach to the Supreme Court and say that my rights have been violated, please intervene. The number of cases in Article 32, which primarily invoked by the Supreme Court in the case where grave injustice or something is happening, a right to life, then they take out the PIL and normally they are filed under Article 32. One of the examples is Delhi pollution. Directly 32 went to Supreme Court, or maybe an appeal went to the Supreme Court, or something, Bandhwa Mazdoor case or something. But in Article 32, normally the approach taken by the Supreme Court is one must explore his remedies before the High Court. Otherwise, the system will not work. So whenever a petition comes in the 32, a good number of times, the Supreme Court, even if coming to the conclusion that there is violation of fundamental rights, they will ask the particular litigant to go before the High Court. The next article, when the Supreme Court is asking you, please go to the High Court, then in which article? The answer is Article 226. Article 226 is wider. Wider in the sense it has more power than the Supreme Court in Article 226. The question comes how? So, the High Court can issue various writs, not only in the cases where the fundamental rights have been violated, but they can also issue the writs when there is no effective alternative remedy available. So what is an alternative effective remedy? Smallest example, since all of you coming from some kind of finance background, except few, I'm sure there must be few exceptions. Suppose DRIT, there is no judge. There is a recovery case going on. He wants to file an appeal. Where he will go? The appeal is provided in the law. That person, there is an order against that person. So, these people go to the High Court under Article 226. There is no effective alternative remedy available. One more example. If somebody's house is being demolished, or somebody has been taken in the illegal custody, where a person will go? Go to the High Court. Another important example. Whenever somebody wants to challenge, since we have seen that the Supreme Court is one which is the custodian of the law, if somebody feels that the law has been wrongly enacted, for example, in IBC or any other law, the people always challenge the provision of law, invoking Article 226 before the High Court. Meaning thereby, as a constitutional court, the High Court has the responsibility that laws enacted by any organ of the states are in conformity with the Constitution. There is one thing which again comes against the IPs. So suppose somebody files a complaint in the IBBI against a resolution professional. The cognizance is taken by the IBBI. IBBI passes an order. There is no appeal provided. Where that person will go? There is no provision in IBC. Where IBBI has imposed the penalty, then where that appeal can go? No provision in the IBC. He can only go before the High Court invoking Article 226. I do not have any effective alternative remedy, and therefore hearing should be given to me. That is the prayer of that concerned person before the High Court. So that's how these first two articles work. The next is Article 136. Article 136 is leave to appeal. What is leave to appeal? It says if any person is aggrieved by any action from any authority whatsoever in the entire India, they can invoke the jurisdiction of the Supreme Court and say that I have been wronged in this manner. And if the Supreme Court finds that this is a fit and proper case, irrespective of the nature of the order, they can take up that case. That's Article 1. So that's how the court is ensuring that any person from any location in India, for any reason where there is a grave justice, they can come to the top court and ask for justice. This power is very unique and kept in the Constitution for a very valid reason. And therefore, most of the cases which goes in before the Supreme Court are in the form of SLP. SLP stands for Special Leave Petition. However, in case of IBC, there isn't a statutory appeal provided. So, in other cases, it goes as an SLP, but in IBC, it goes as a civil appeal. So, what is the similarity between the IBC and the SLP? So, on the first date of hearing, be it a civil appeal in the IBC or SLP in 136, the Supreme Court is deciding whether that particular order is causing grave injustice or something, a wrong precedent is being set, which can harm a lot of people or grave consequences. Then they accept it and hear it. Otherwise, a very short order is passed that appeal is dismissed. No reasons are given. Why the Supreme Court no reasons are given? In Supreme Court, reasons are not given for the reason that there is no court which is above the Supreme Court where reasons are to be tested. So coming back again to the principle of natural justice, one of the components of the natural justice is if a case has been decided, the person must know what are the reasons which prevailed upon the judge in deciding that particular case in one way or another. These very reasons which has been given is scrutinized by the appellate forum to see whether these are justified or not. Like in NCLT, NCLAT, then in the Supreme Court. However, the Supreme Court need not give any reason, being the highest court, so they may dismiss. But all other forums in India are accountable to the Supreme Court, and therefore they are required to give reasons for reaching to a particular conclusion. So, coming back to the original idea, when you go before the NCLT or NCLAT, the first thing is notice. Second is completion of pleadings. Then the order for which the reasons are given. And this format is followed in all cases. So, any questions so far? It will be really helpful if you people ask the question. Otherwise, monologues are very boring. And all questions are correct. Yes, sir.
Generally, many of the advocates do not have the advocacy background, sir. That is the problem.
Many of the advocates?
Many of the IPs, sir, do not have the legal background.
Yes.
In every IP, because at the same time IP do not play as a dual role as an advocate at the same time IP. He can role as only one role only at a time.
Very relevant question.
Yes,
And
sir.
it I'll give you that answer, which will help you in deciding that.
Yes.
So before the answer will come from the background, how the legal profession developed.
Yes.
Okay. So law was not a profession in ancient times, long back. So when we see the development of the law, there was a King's Court in UK. We derive our present legal system from the UK. There is no secret. It's as it is copied from the UK with minor alteration to suit Indian situation for the colonial powers imposed on India. How it developed in UK? So originally, when there was King's or Queen's Court in UK, the people used to go to the king and say that I have this much of the land, and the person is taking revenue for this much of the land, or some person has beaten me, or whatever may be the reason. These people were going to the court and asking the king or his representative, give me the justice. So sometimes these people were able to get the justice, sometimes they were not able to get the justice. So in front of these courts, some other people who got some kind of experience in presenting their case before the king or his representative started the tradition to help the people who were not so eloquent or he was not so well versed to put their case before that person. Because law is all about communication. The lawyer is doing one single task. He is presenting the case of the client in the best possible manner in writing and orally to the court. It is just a medium. Nothing more, nothing less. So these people started staying around the thing. So the people who were not good at speaking or presenting their story started saying, okay, you go, you present your case, my case, and if you present well, I'll pay you something. So truth of the story I am not aware of, but if you have typically seen the advocate's gown.
Medial, if you go to medial level advocacy, we would have to find out all these things, sir. Yes, you are absolutely right.
Yes.
This is the way they evolved the law from 6 centuries.
6 centuries. So if you see the gown of an advocate, you will see that there is a small pocket at the back of it.
Yes.
So people used to put silver coins or the gold coins when the person is arguing well, and this is how the profession developed. So in essence, the advocate was started performing the task of the client in front of the king's or the queen's court. Now, how they got their black gown and the robe? Some relative of the king died. All these professionals who were going regularly before him donned upon themselves the black robes, went to the funeral. So the king was pleased. They said that this will be your dress for the rest of the things. So that's how the black shirts and things came up. To cut the long story short, since the 6th century, as you said, or the earliest of the time till today, the role of the advocate is only to communicate the client's story to the decision maker. Now, you have pointed out that IP and advocate, both the practices can be done or cannot be done. So I'll give you the answer in a slightly different way. See, it's a layer. It's a layer between a judge and the client. So judge can communicate what is the drawbacks in legal language to this layer, which is an advocate, and he can communicate in his language to the client. If you remove your layer, then the communication gap increases and chances of adverse order also increases. So day in and day out, you will, now the Supreme Court is in the YouTube, or many of the courts, high courts and everything, you can see them. NCLT virtual proceedings have started. So the people who are not skilled or by practice, they are not there. They are not able to present the case well in the manner the judge wants, because ultimately the relief is given by the judge.
Yes.
Okay, so therefore that layer is essential. So even if that judge is heavily angry with the client, he can say whatever he wants to say to the lawyer, but he can't get angry with the lawyer because he is only a messenger.
Yes.
Okay, so it protects in some way the client. If that layer is removed, then the consequences are not very, you can say, happy. So whenever IP decides to represent himself, or NCLT calls him for any mistake which NCLT feels, then chances are higher that he will directly face the heat of the judges.
Yes.
Okay, so he will be deviating from his core responsibility, and he is exposing himself directly to the judge. Might be incorrect as well. I'm not saying that the IP has done all the wrong. Okay, but somebody before the IP opens his mouth has been given an opportunity to the speak. Okay, that person has never said something good about the IP. Take an example of a creditor. He will always say, Gotala kiya hai. He has downgraded my claim, wrongly categorized. There is a calculation error. This document was not considered. And suddenly the person as an IP comes in between and say that, let me answer. And he says that you are the person. Okay, so in this entire story, there are two answers to your both the questions. One, is it a good idea to remove that layer? In my personal opinion, not applicable to anyone. There are some of the IPs are way better than many of the advocates, not questioning capacity. But once you remove the layer, you exposes yourself. Then, secondly, if an IP tries to become a lawyer, it's very difficult for him to perform or manage a company, because the court system is such that in a day 50 matters are listed. You might stand in the courtroom for morning to evening and your case may not even reach. So that's not even economical or a prudent use of the time. Of course, the IP must make. Yes, there was some question. Okay, I think it was by mistake.
No, actually, sir, what happens is he will be doing this at the cost of his other works also. If he's wasting so much of time, if an IP is wasting so much of time waiting in the court, and in that case, he will be doing at the cost of the other works also, which he could do otherwise.
Right, absolutely correct, Singh sir. So that's how they are doing at the cost of something. So that's why it's not advisable. And being a subjective subject, the people who remains in the court know a art really well is not to speak. The art of speaking is as much important as art not to speak. So by sometimes what happens is that court feel कि ये आ गया तो ये कर देना चाहिए था, ये आ गया तो ये लड़ लेना चाहिए. These feelings comes in the mind who is the client. But the person who is standing on the dais, he has a different thought process going on his in mind. He is trying to protect your interest. He always need not win the argument with the judge. If you win every argument with the judge, judge might not give you the relief. It's not the question of having a better argument. It is or winning the argument. It is the question of presenting your case in best possible manner so you get the best relief in accordance with law. That cannot be done effectively unless you have that particular layer in between. Sometimes what happens is that if their case is 100% straightforward, court even appreciate that IP must come. Take an example of the resolution plan. 100-page document. It should not happen that IP should not go to the court. Why? Because there are hundreds of factual questions. As a lawyer, suppose a lawyer having a 4 or 5 brief in a day, he won't be able to remember the minutes of the meeting and the financial data of the entire resolution part before the court, and court can ask anything under the sun. So it is advisable to be there to assist your lawyer so he can present the factual data correctly before the court. Any other questions, sir?
Sir, tell me one thing. I have a small question. I am neither a CA, CS or nor an advocate. I am just from the technical background. So sometimes I feel that, okay, we have studied all the acts also, you know, like Companies Act and all the acts we have studied and passed the examination. But sometimes I feel that it may be difficult for me also to stand in the court of law for that. Okay, this advocate layer is very good. I could understand that. And then some of the facts I can present myself if required. But anyway, sometimes I'm afraid of it. So please just remove my fear for that.
Singh sir, the first thing, the fear should never go away. It's not only you, even the top-notch Supreme Court advocates, senior advocates have that fear of the dais. And a small amount of fear is always good, so you prepare it better. One of the key to prepare well, if the student, it's a kind of an oral examination on a particular file. If a student will not have the fear of examination, he will not study. And if he will not study, the chances of failures are more. So having a fear
correct
is beneficial. Another thing in law is that it is an open book examination. You always have all your documents before yourself, meaning thereby there will be no surprises. The court system ensures that the same set of documents are with the person who is representing one party, with the other party, as well as the judge. So the system is designed in the manner that all three of them have same set of documents. If you do not know the answer of any of the questions, you can very well refer to those papers. In case you are not able to recollect the answer and that particular fact is contained in that file, 99% of the cases, the court will give you the time to study and find out that fact. In the Delhi courts, you can ask for passovers. That practice is very prevalent. And you come in half an hour or 1 hour when the matter is called up, and then you can explain that fact. So that's my answer to Mr. Singh's question. Mr. Singh, you are there? And think we lost Mr.
Yes,
Singh.
sir, I am there, sir. I am there, sir. I have clearly understood it, sir.
Thank you. So that answers your question, and thanks for your question, sir. Any other question? We have already crossed 1 hour mark in almost a complete monologue. There are very few people who are participating in the discussion. I request all of you, or at least those who can switch on their video, to open it and ask as many questions as they like. Okay, so that's one of the most difficult part of these seminars, that sometimes you feel alone in the group of 20, 30, and you don't know who is listening and who is not. But
सर समथिंग इज प्रॉब्लम फेस पे, इसलिए मैंने बंद कर रखा है.
अच्छा सर, नहीं, बट आप हल्का सा ऑन रखिए, इट विल हेल्प. Hi Tejas. So I can see some of my friends. Tejas is another an AOR, and I can see some people have wrongly mentioned their name. The face is different, the name. So either way, so any questions so far? Okay.
First of
So,
all,
yes, sir.
First of all, I have to say congratulations, sir, because very few advocates are advocate on record at the same time IPs. I think that the advocate as well as IPs, I think that the number of list is less than 10. I think that in a award list. Am I right?
Yes, there are very few. One is before you. Tejas is another AOR.
I don't know still. Actually, I am also a AOR aspirant, sir.
Okay.
I'm practicing in Hyderabad.
Wow.
I'm also advocate come IP. Yeah.
Yeah, there are very few. In Hyderabad, there are few actually. There are few advocates who are practicing as an IP.
And just for everybody's reference, Manish sir is a very, very learned man. He is not only in AOR, he has several other qualifications. So if you see his resume, we all get inspired that, that at such a young age, he has achieved so many qualifications. So I learn from him all the time, and that is why I've joined his lecture also today.
Thank you, Tejas. He's a seasoned counsel. Thanks. It's always good to receive praise from the fellow. So that's how the entire architecture of the legal system is developed, and the system thing there. Now, I wish to deal with few of the issues which IPs face with their advocates, or they have these kinds of the questions. I have taken these questions from one of the literature available on the net, and the sequence of the next things will go like I'll frame a question and then tries to answer, and if you have further questions, you can top it up. So, the first question is, like, when you become a lawyer, what all are the laws which are applicable to a lawyer and to an IP or the cross-reference? So number of laws which are applicable on advocates and how he conducts his entire hearing and everything is way more than as an IP. Though the responsibilities casted on an IP is way more than an advocate. So that's the difference. The advocates are governed by the Advocates Act, Bar Council of India rules, CPC, Civil Procedure Code, Code of Criminal Procedures. Now the name has changed and the provisions have been changed. Then numerous circulars which are being issued day out and day in by the Supreme Court as well as the High Courts. Various judicial pronouncement, etc., and the training rules. So these are prominently the set of laws which are applicable to the lawyers. However, the scope of duties which a lawyer performs is very small compared to IP. How? The lawyer is just a messenger. So he can do only according to the instruction of the client. He is not supposed to do anything which his client doesn't instruct us. So be it in writing or be it orally, the content of the communication is controlled by the client in all manners possible. The limitation which is being placed on this content is by law. Like he can't offend, like he can't fight with the judge. So that's the limitation. Otherwise, if he is being civilized and presenting his client's case, then these things like his communication, the duties of the communication only. In case of IP, the IPs are governed by IBC and set of rules which are propounded by the IBBI. These set of rules have like how everything is to be done, rules, regulations. There are several things within that. Despite being only one act and one regulator, the scope of responsibility is way larger. The IP become a CEO of the company, kind of CEO, not exactly the CEO, who runs the affairs of the company on the instructions of the COC, and thereafter it becomes a quasi-judiciary authority in the liquidation process where it takes the decision. However, a lawyer cannot take decisions on the behalf of his client unless instructed to do so expressly. So everything has to get no compromise without the client's consent. Nothing. IP can keep the company as a going concern and take all the decisions. He has to get it validated. Many of the decisions, as per the IBC, verified or approved by the COC. But there is no such thing in lawyering. There is no COC, nothing. So the nature of the responsibilities are completely different. And therefore, there is a dedicated system to manage these responsibilities and the things. So the nature of responsibility. The second thing which a lawyer is and which IP is not is the officer of the court. So in entire jurisprudence, the lawyer has been recognized and given the thing which is called officer of the court. So like a judge, he is an instrument in the judicial system to help the judge to reach to a correct conclusion. The responsibility of IP is to maximize the value for the stakeholders. A lawyer is not supposed to win the case by speaking lies, or he need not maximize the wealth of his client. He is only supposed to communicate the law and the facts in best possible manner to the judge. However, an IP has to take the decisions how the assets are being sold, what is the correct price, what is how the resolution plans are structured, what should be the contents of information memorandum, how things are to be advertised, whether all the stakeholders have received notice or not. Is there somebody who is trying to take the company by backhands and etc. 29A? All those are managerial responsibilities which a lawyer never has. So that's one of the key differences. A IP is an administrator come manager. An advocate is just the representing the client before the court, no other authority. IP has to go to several places to represent the companies, be it tax authority, be it the regulators, be it the creditors, etc., etc. That's the fundamental difference. And these things has to be understood when somebody tries to compare two professions. So that's the difference in the role. So whether everybody has a fundamental right to be a lawyer, that's one of the questions. So lawyering is not a fundamental right. Neither the IP is. It's in itself is a profession. You have to cross the hurdle of the exam, and then you have to practice in the courts at least in some other manner to remain a lawyer. So it's something which is, you can say, regulated by Constitution as well as the Advocates Act. If you fulfill the qualifications, you become a lawyer. If you fulfill the qualification, you become IP. So there is one similarity here. Be it a lawyer, be it a IP, you can be successful only when your client has trust in you. Because both the professions are the professions of trust. Nobody will entrust you a file just because you have a degree. Or no COC will have an IP on which they don't trust. So trust is one of the essential component in both the professions, and both the professions require high level of integrity and impartiality. Impartiality in the sense, a lawyer has to be true to his brief. Similarly, the IP cannot favor one stakeholder over the other. If in law somebody is entitled to something, so he has to take a correct stand. Sometimes the COC might pressurize on some of the things, but being appointed by a tribunal under a statute, merely because that the COC is paying and there is some kind of conflict of interest there because the person who is appointing you or paying you wants decision in their favor. You are not supposed to succumb to these pressures. Similarly, a lawyer is not succumb to the pressure of the client or do anything or speak anything before the court. So those are some of the similarities. Integrity and the trust are one of the key components of both the professions. The next questions are the relationship which we have already discussed is of the trust. Then one of the things which comes to my mind is that the next question is how far a lawyer can go to present the case of his clients to the judge to get the relief. Since it has, we have again crossed 15-20 minutes. So any of you have any questions so far? Or suggestions or sharing the experience is most welcome. Because there might be some of the people who might not be very happy with their current lawyers. Or other way around. A lawyer is not happy with the clients. I think all of you.
In a total IPs, there is very 5 to 6%, less than 5 to 6% are represented by advocacy.
Yes.
More than 60 to 63% they are the CS. Second majors are CS, next CMA. Very few percentage of only the advocates. I think 5 to 6%, less than 6 to 7% below.
Perhaps the chartered accountants are more or not? I think the chartered accountants.
Yes, more than 61%. There are 61 chartered accountants will become RPs. In the total RPs, total
Yes.
IPs.
Yes. So most of the people are here, the chartered accountants.
I think that's what I'm saying. Less than 5 to 10% of the advocates acting as an IPs.
Yes. So any questions, Swasji, so far?
Mostly are company secretaries here, sir.
Yeah, second category, second best is second highest level is company secretaries. Later CMA, bank employees, last category will be advocates.
So there is only one question. Is there any time limitation for filing appeal to NCLAT against the NCLT order?
Yes, it's 30 plus 15 days. So 30 days is for filing the appeal, and 15 days it can be condoned by the NCLAT. So you can take it 45 days. After 45 days, the NCLAT do not have the power to condone the delay. So that's a very pertinent question, and it affects many of the appeals, because there are very few laws where such a short period is prescribed for filing of the appeals. So,
is there any provision, say, for example, under section 43, 45 or 66, order
61.
has been issued? Order has been issued by the NCLT to deposit, say, for example, 2 crore rupees within so many days or 15 days. Say, for example, an order has been issued that X party is required, or management has required to deposit X amount before 15th of October. Now, the question is there any provision if the party wanted to move to NCLAT, they need to pay at least some amount in the corporate corporate debtors account of the penalty which was imposed by the NCLT?
No. There is so the question, if I understood correctly, is that like there is any pre-deposit condition if they want to file an appeal.
Correct.
So those conditions do not exist in IBC. In DRT, there are conditions where you want to file an appeal, so you have to deposit X amount to the court, or in arbitration, like in MSME, if somebody wants to file and challenge the award, then you have to deposit 75%. But in IBC, there is no such condition. The only thing which you are supposed to pay for filing an appeal is the statutory fee, which is close to 5,000 rupees, and some other expenses, which is like court fee, etc. So it roughly comes around 5,000 rupees plus 100, 200, 300 rupees in the small tickets here and there. Otherwise, there is no pre-deposit. Irrespective of amount, it's 500 crore, 1,000 crore, 5,000 rupees is the only thing.
So RP like us, we keep fighting with these kind of people, because COC member or SCC member, they refuse to pay any fees or all these things. For example, if I am fighting for a couple of years before against the management in the NCLT level, now NCLT order has been issued that certain amount has been required to deposit. They move to NCLT. So again, I don't know what is the time limited within what time period NCLT probably respond to this particular case. So to keep fighting for years and years is what the point is, without money.
This is one of the biggest drawback when it comes to the remuneration of RP is concerned, or even the liquidator is concerned. So they have designed a law in such a manner that if you can't realize, it will have the first charge. And since you are absolutely right, there is no time frame. So absolutely, it may take years. And one of the reasons, so all the sections you have cited relates to the avoidable transactions, which are like overvalued, related party, or fraudulent transactions. There is another challenge associated with those transactions. The challenge is those are questions of facts. So typically what happens in those applications, the avoidance transaction applications, the IBC mechanism is far from perfect. That's my personal opinion, for the reason that IBC says after so many days, within certain period of time, the RP is supposed to identify those transactions and file an application before the NCLT. The one of the challenge as an RP is that it's not possible within that time period to identify those transactions. Since IBBI says many of RPs to check the compliances file those applications. In order to substantiate those applications, what they do, they appoint, since it's a burden to identify those transactions, so they appoint a forensic expert. The forensic experts are normally the chartered accountant have conducted a lot of audits. They typically focus on the auditing parameters and identify those transactions which they feel might fall in these categories. Based upon that particular report, the RP supposed to make a decision, but normally what they do, they annex the report and file an application. Sometimes they don't even do the segregation of these transactions. Now, invariably, these transactions involve third parties as well as the promoters. Typically, these are the people related to the promoter or the third parties who gets affected. And all these are question of facts. How it is a question of facts? Say, I'll take undervalued transaction. You have identified, you have taken a particular benchmark of a certain property. I'll taking an hypothetical example that one RP says that this was a 100 crore lands. It was given to some relative at say 75 crores. There is a huge difference. And he takes a few benchmarks like market rate, magic bricks, valuers report, and this is much per down price. Therefore, this much recovery is to happen. The challenge when you stand on the other side of the dais, like you are speaking as an RP, but if you see as a promoter, he was in a desperate need of money. Company is going into the liquidation or a CIRP mode. Nobody is ready to pay the money. This was the only relative who has the money and ready to bet on him. Despite the fact that the market price was 100, he could not find anybody better. He sold it for 75, or maybe he sold for 100. Hence, he required 25 in cash, so that 25 never got reflected in the balance sheet. So all these transactions have multiple questions of the facts, and which is to be decided to decide that application. But the NCLT doesn't have the time and requisite information and resources to decide those applications very judicially. Some of these applications are decided very hastily. Some of these decided are like, it's a guesswork. Okay, this might have happened. Okay. Another problem with the entire system is that in all the lectures or in all the narratives, initially a narrative was built up that it is to help the business people and etc. to resolve. This is what the statutes say. But a media narrative was built that all these promoters who were driving the business were siphoning of the funds. So there is an inbuilt prejudice in the mind of the people who are scrutinizing this transaction that कुछ तो गड़बड़ करी होगी, इतनी बड़ी कंपनी नीचे कैसे चली गई. Inherent bias. Okay, it's a subjective subject. One might be right, one might be incorrect. So the time period which NCLT takes to decide these applications is long. It is going to be longer in NCLAT. And if they succeed in getting the Supreme Court successfully issuing the notice or the stay, it will be even longer. Okay. So I have two pieces of information which I would wish to communicate you as a lawyer. You are, I'm sure you are a company secretary or chartered accountant? Company secretary. Yes. So two things which I wish to communicate. You can't bet upon the committee of creditors to fund you that long with the litigation goes. It might go 5 years, it might go 10 years, depending upon the case. It's very difficult to recover those amounts because recovery is one of the toughest thing in India. In IBC, if the early recovery is there, settlement is there, it's the highest. If it goes into the liquidation and avoidance transaction, it's very difficult. Okay. So you have to find alternative, innovative means to pull yourself out of these things. You go to
like what?
You go to NRRA, avoidable transactions, sell it off, whatever it may be, move proper an application, because many of the insolvencies, take this Jet Airways, I don't know since how long they are going. Since the beginning of the IBC, I think. Okay. Maharashtra Seamless is also going for a long period of time, multiple judgments, the IP fee. So in IP fee, which was the bottom line in this entire discussion, is how the idea is not to put yourself in a deep trouble, but at the same time ensure that your stakeholders doesn't cast any doubt on your intentions. Otherwise, to expect it's going to be decided, no. Earlier, NCLAT was very fast, particularly the bench number 1 is going in a very, disposal is very fast. Now every bench is hitting 30 to 40 meters. As a human being, like in a CS, you did CS, I also did for some reason, but let's take an LLB exam. A student get an entire year to complete few hundred pages of the book, and a judge gets 60 such books to complete in a day. And all of them have the different facts. Humanly not possible. So the dates will be longer. As soon as the pendency increases, every tribunal loses its focus, resources get diminished, and the pendency goes higher. So there cannot be any time limit which can be fixed. If the COC is not funding, then you can put to the terms, move an application before the NCLT. Otherwise, the it becomes a cycle of hope.
Sir, can I interfere for a minute?
Most welcome, ma'am. I'm happy to have the questions. There is somebody speaking.
No. Actually, in fact, there are two things involved here. In fact, I want to thank you because you have given the other dimension of an advocate if you are going to be the corporate debtors advocate, and that dimension really very good. Now I'm able to appreciate why it is taking time in NCLT. I mean, that is very good. Second, my observation in this regard is in respect today, Ambiga Sugars, if you recall, okay, in that case, they said if your company is sold as a going concern, they asked us to create a trust to transfer all the avoidance transaction to that particular account, and amount should be kept there. It should be funded by the COC because avoidance transactions, whatever the benefit you are going to receive is to be given to the COC members. So this is the latest provision. Accordingly, most of us were filed an application in respect of this trust account so that the company after the sale as a going concern is continued to happen. Okay, but one thing is definitely a challenging task is certainly getting remunerated on time. There is no second thought on it. Even though IBBA says regulation, all these things are happening, under any circumstances, as an IP, our life is sometimes, not sometimes, most of the times, difficult to collect the money on time. However, since the company is sold as a going concern, there is some kind of a fund available which we are willing to transfer as a trust funds to utilize for our use. This is the latest technique or latest available area where we are making money and keeping ourselves properly remunerated. This is the latest way. But whatever you are going to say on avoidance transaction, it's a Herculean task. When they are going to close, it's absolutely nobody can guess. As you have very rightly said, NCLT, they cannot do it immediately. It will be automatically adjourned, NCLAT once again, Supreme Court, God only knows. But there is some time limit. But this NRRA also, people are not willing to take it over. We tried in 2-3 cases. We requested the Committee of Creditors to take it by themselves, kind of this thing, because it is unnecessary. They are little bit afraid and they are asking 100 questions. I mean, these are the views I personally having it. So I thought I can tell you about this. And thank you very much. Today I've got a different dimension. Thank you.
Thank you, Anita ji, for the enlightenment. Now the Suhas ji got some idea how he might try to. Okay, so thanks for the suggestion and thanks for taking part in the discussion. And thus NRRA transactions, they have their own problems of their own. So just want to share something. This is not something very new. It has been given a new name. But this particular type of transaction existed in the law since like even 18th century. So if you see the definition of actionable claims in Transfer of Property Acts, so somebody wants to enrich their knowledge about what difficulties a person might face in deciding or adjudicating those transactions, one must go to the two things. One, the actionable claims in the Transfer of Property Acts, and similar provision existed in the Companies Act as well. So in both these provisions, this kind of market, they thought that a market will develop, that somebody will take the risk of realizing money from these transactions and capitalize the stakeholders' wealth. The IBBI took a clue from the developed markets and incorporated those provisions in the IBC. Now, the challenge in Indian market and the developed market is enforcement or recovery. So in the developed jurisdiction, the people are willing to buy those claims because they know they can enforce and get something out of these transactions. But most of the time, the Indian bankers are not willing to pump in more money in a shrunken ship to recover something which they are uncertain. Like till the case is decided, I don't know where they will be, in which branch, or whether they will be associated or not. And any other person is not willing to buy those things for the reasons that even if assumingly you win in NCLT, it's a long way to travel in NCLAT, Supreme Court, and then execution. Even if you win the case and you got a paper in your hand that pay 1 crore, but in order to get that 1 crore, you have to go to his house, attach the property, make him insolvent or something like that. That takes a very long time and it's very difficult and time consuming, so it's not viable. So that's what the entire challenge is. So I hope, Suhasji, you got the answer of your question.
Right, sir.
Any other questions, sir? Any of you?
Sir, I want to ask one question, sir.
Yes, please.
Sir, regarding the remuneration part only, like
Mhm.
in the small cases where the SCC is not interested in continuation of the CRP process, or where the they are the sole COC member or the SCC member, where there is a settlement during the liquidation stage.
Mhm.
So what happens that the SCC members are not willing to pay the liquidation fees, where there is no assets in the company or there is no chance of any recovery by selling of the or liquidating the assets. The company got dissolved. We file an application before NCLT for fees. NCLT passes the direction upon SCC members to make the payment. SCC members are not responding. We are filing the contempt application also. They are not responding. They are not reverting any emails. They are not appearing for the SCC meetings. Years and years are passed, but we are not getting any help. So in those cases, how it's possible to execute the orders of the NCLT? Same is also happening in the 19.2 application also. They are not appearing. They are not filing any affidavits. We got the police order. We got the NBW. But those are of no use. It seems like the people are not giving any importance to the NCLT order. Like in the criminal court, if the CGM pass any orders, the people will come and get the bail. If the High Court pass any order, people are giving the importance to those orders, but not with the case of NCLT.
So the problem which you have pointed out is a genuine one. That's rather like a very well statement. Whether you got the order, even NCLT help you. In good number of cases, the NCLT is not even helping. Okay, so you were lucky in the sense that you at least got an order for them to pay. Okay, but what I feel is, and where this discussion becomes really important, is that there are some similarities in the profession of an advocate and an IP. Okay, in the sense that as a resolution professional or as an advocate, you can't think or assume that the one brief you have will make you money. Okay, there are like the Attorney General I think the last attorney general in one of the interviews stated that even at that stage, like he reached the pinnacle of the career, he was supposed to write off 15% of his fees, like total billed amount. So 15% is non-recoverable. So there is no legal answer to the question, but there is a practical answer to the question is that if you decide to practice as an IP, then you have to assume that some of the cases are going to make losses or their fees are getting non-recoverable for a very long period of time. Unless you go with that thinking, it's very difficult to be one assignment and I will make money. No, it will not work that way. So the most of what you can make as an advocate or as an IP is to diversify your risk. As long as a professional, you are not keeping all of your eggs in one bag, you are safe. And you just have to ignore the bad eggs.
Sir, by profession, I'm also an advocate, so I understand that in some cases we have to forego our fees. But
Yes.
I believe that IP is not like unlike a profession like an advocate that if the client is not paid, that those money are bad debts. We can write off those. Those are the some which we are doing as an officer of the court. It's not willingly that we have accepted a brief, works or not, we will forego the client or we will give any discount. We cannot negotiate on the fees that the minimum fees is 1 lakh in the CRP. Okay, you pay me 50K. We cannot go below the threshold limit also as per the fees. And all the regulations are upon the IP. If the COC member is not responding, IP is responsible. If the suspended management is not responsible, IP is responsible. If the NCLT is not taking any steps, IP is responsible. So IBVA is only in the charge of the IP that you have not performed your duty. They are supposed to act as without fees pro bono. They want us to act. You have taken the assignment. Even if you're not getting fees, you have to make the public announcement. You have to appoint the valuer. I have to pay the valuer fees. During the liquidation also, sometimes we have to appoint the valuer. So we have to incur the expenses without hope, with an expectation that I'm not going to get any money. Then IBBA will quote you why you did not perform your duty. In case of advocate, we can give the NOC. Okay, you are not giving me money. Take the NOC and go. So,
Sir,
how to deal?
So
sir, can I speak here, sir, for a minute?
Yes, thanks, sir.
I'll share my view in this. Actually, we have to be very particular about keeping the records. If COC is not doing anything or if somebody is not cooperating, we should write to them by mail or by any other mean. And that record will help us. This is what I feel in this case. And secondly, sir, one thing, another question I'm adding here. Like I started my career as a technical consultant. I am doing surveyor and loss assessor work, chartered engineer, registered valuer under Wealth Tax Act and Companies Act. Now I have become IP. Now, if I diversify, like IP is such a busy job. First 30 days you cannot do anything till the first COC. So will it be justifiable to go for the other fields also as well as working as an IP? So just these two things I just wanted to convey if it can be said.
Okay. So the last question of Singh Saab, I'm trying to recollect all the questions and trying to answer it. The first is the easy one I'm taking. So Mr. Singh Saab says, is it advisable? Of course, if you are asking my advice, yes. Okay, sometimes the IPs take one assignment and even the first one makes the losses. That's the story of many of the IPs. So to think that the first few assignment will make you a profit guaranteed, no. Secondly, the question which has come from Udit, I'm really happy that he is a lawyer and IP and put up that question. And he made the distinction very clear in the two professions. So the similarities and the distinction. So he pointed out the distinction. As a lawyer, you don't have your skin in the game. But as an IP, you have your own skin. You are incurring the expenses. You are taking upon the time, and it's way more time consuming than a lawyer or a particular case is. A lawyer can handle, like some of the successful lawyers argues 10 cases in a day in a Supreme Court. But as an IP, it's very difficult to have 10 COC meetings in a day. So that's a valid distinction. But there are perspective gap in the entire system. Right now, the entire judiciary in this NCLT, LAT is manned by the people who has no experience to work as an IP. So they are unfamiliar with the pain of an insolvency professional, which one has to undergo to perform a particular assignment as a such. It has the negative implication that the people are not realizing that how painful it is, and they are passing 1, 2, or multiple orders against the IPs, and the fee is not granted. At the same time, they are still considering that if some of the omissions are made by the IPs, they are ignoring it. If you take the history of as a profession, the IBBI started in a very relaxed mode as far as the violations by an IP is concerned. Gradually, it is becoming stricter, and sometimes it is becoming painful when the notices are being received for very small things. Even they don't have an infrastructure, but still the explanations are being sought from an IP, which can never be sought from an advocate. But be that as it may be, these are the realities which we must understand and structure what we have. Secondly, as rightly pointed out by Udit, it's very easy as an advocate to say that if you don't pay the fee, take your brief, go out. But however, there is a small thing. As per the Advocates Act and multiple judicial pronouncement, even an advocate cannot give up the brief if he has not been paid. So that thing is identical. At least an IP can go to the NCLT and say that my payment fee has not been paid. But in case of an advocate, you can't even go to the court and say that my fee has not been paid, so I will not appear. So if we compare the provision of the CPC of releasing of the brief is in some context way more harsher than what it is for an IP. So that's the kind of similarity. But some of these things the people are trying to search for the answer. That is one of the hottest topic in all kinds of conferences which are organized somewhere. The question of fee comes at some point of time. It takes most of the time, and despite the fact that all the brilliant people are devoting all their minds, they are unable to come at a simple solution which can be given. I think it's my personal opinion that the conflict of interest situation is harmful. Why? The law has been designed where the person who is trying to enforce the recovery, COC, they are like, come what may, they are using it as a tool to recover the money or maximize their asset, is paying the IP. And IP is even supposed to check on their actions. So if IP is not performing according to their will or according to their targets, they are not paying. So somehow the law has to be modified to remedy that situation, and then only the solution will come. Till somebody removes that conflict of interest, it is difficult to see in the present architecture of the law how this solution will come. Because remuneration is paid by the person for whom you are supposed to even regulate to some extent. Very difficult. In some of the cases, COC says, if you don't admit my claim, I won't pay. Or even if I'm not getting the recovery, I have a slim chance, I will not pay. In one of the Calcutta case, like this, and I think it must have happened in many cases, the petition is admitted and thereafter nobody came to form a COC. Neither no operational or financial creditor ever came forward. So that's something which is the market reality. And one must think, unlike a job of a lawyer which is doing the crisis management, The IP is given the responsibility to manage the graveyard of the companies. It's the businesses which have gone into the losses already, not able to pay, defaulted. It's impossible or it's very difficult to design a system where you can enforce 100% of recovery for anybody in such a architecture. So that's my thinking. Any other questions, sir? Udit, do you want any follow-up answers?
No, sir. Thank you very much.
Thank you. And thanks for sharing your thoughts.
Can I extend a proposition?
Yes, please, sir.
मनीष जी अभी आपको पता होगा अभी एनआरआरए में लेटेस्ट जजमेंट पास हुआ कि इट शुड गो टू द appropriate remedy outside the IBC, not the adjudicating authority. NCLT should deal with NRRA. So what do you think about these propositions and these things?
If that happens, if that is properly executed, that would be far more effective, at least in few senses. Because suppose if it goes to the normal civil court, that court has the power to enforce the attendance. That court has already the entire infrastructure which is time tested to make sure that the recoveries do happen. So if these cases goes to the regular civil court for the recovery, the chances of recovery will go higher. The questions will be determined fairly. What my personal thinking is that once the company goes into the liquidation, there must be some provision which must give an easy exit to IP. If the stakeholders wants to recover something from anybody else, they must be given a liberty and they must pay for it. But the liquidation will come to a quick conclusion only when the IP is taken out from this thing and says that, okay, you have done your job. This should not be a job of IP to prosecute these applications till they get decided. Until that comes, these problems will persist.
Correct. But at the same time, these NRRA being totally in air asset, and stamp duty, court fee is to be paid at a very which are very higher in amount in civil courts. There's a 2% or all these things. It will get affected the recovery and the prosecutions to be launched in civil courts rather than to go in NCLT. What do you think?
That's one of the challenges. That's one of the challenges. But my take on entire system is that if the chances of recovery is less than 1.5%, that claim is not worth fighting for. So the court fees, if you take typically example of Delhi, it's after a certain threshold, it's 48 rupees point some paisa for every 500 rupees, roughly translate to 1 point something. If somebody has valued that NRRA 100 times more, then the system lies with the fault who has put that value on it. Okay, so somebody has not applied his mind correctly to put a value on that undervalued transaction. Because what is it? It's a related party transaction, undervalued transaction, extortionate transaction, fraudulent transaction. These are the categories. In either of the categories, if some RP has taken the risk to value them 100 times more, then that is a risk. That has to go with it. To my understanding, a case which can't pay even the court fee is not worth fighting for. Come what may the reason. The Indian judicial system is one of the most accessible system across the world, where the poorest of the poor can go up to the topmost court and say that give me the justice, whether they have a lawyer or not. The entire ecosystem and the entire profession of lawyer is one of the most democratic, where the people come from the rock bottom strata, like the poorest of the poor and the richest of the richest. So it is one of the most democratic system. Anybody can take an entry, anybody can represent anyone, all of them are equals. Like if somebody is arguing in the district court and if some top lawyers is coming from the Supreme Court, they are at the same level. So even in the democratic system, if the people are not able to defend even the 1%, I think that's a false burden. And that's where the challenges lies. The challenge like because IBC forced the RP to identify the transaction. So for the compliance sake, the transactions are being identified, not being verified. Some of the times, some of the transactions you can see that the forensic report and the bank transaction, the passbook entries are not matching. Like forensic auditor is just taking the Excel sheet, making a very beautiful report. ChatGPT is coming to the help. Okay, but whether that forensic report is good or not, it depends upon two factors. One, whether there are proper evidence which can be proved in the court. One. Two, whether that value is according to that transaction. So suppose undervalued transaction, I'm repeating the same point. Somebody says that even it is not 1%, it can recover 100%. So what was the forensic audit for? What value did it carry? So it's the correct way of taking it. If system works only when everybody performs as per the duties assigned to him, faithfully and responsibility, then the system will work. If somebody is meddled with the thing at the stage of identifying the transaction, valuing the transaction, how you can expect the court to give the recovery? The value was never there. I hope it answers your question, sir.
Correct. To some extent, yes, it is correct. Value lies. Where is the correct value? Is to be identified correctly. If it is not correctly identified, then problem will persist in at every forum.
If you have any follow-up question, I will try to answer in best of my capabilities.
Thank you. It's answer all.
Thank you, sir. Thanks for your question. Any other one? Anyone else who has a question? I really request somebody to switch on the camera because right now all of them have switched off and I feel that I'm the only one in the seminar listening to myself. Thank you. Thank you very much. So, coming back to the topic and little bit of monologue before I'll request any of you to put forward a few more questions. So, how far a lawyer can go to put forth his argument? So there are many instances and there are cultural instances as well. Cultural differences between the high courts and various jurisdictions. So typically, if you see the argumentative style in Delhi, it's comparatively more aggressive than what you say in South India or even Bombay. A lawyer is never supposed to intimidate or terrorize a judge to get the relief for the client. This should never ever happen. He should always be truthful to his brief. So it's not a job of a lawyer, but particularly to the public, contrary to the public perception, lawyer is not supposed to get the relief for the client by hook or crook. This is completely wrong. The lawyer is an officer of the court and he must assist the judge in reaching to a lawful conclusion. So that's one of the lawyer's responsibility. Who can represent themselves? So this topic has been framed. So in India, even a party can represent himself in all the forums, but only the lawyer is authorized to represent the case of others. So that's why he is a lawyer and he is a practicing professional. A person, when IP goes before the NCLT, he is kind of party in person. He is representing himself. So all the challenges which is in representation of the party in person is he faces the same. There is no necessity that one must hire a lawyer. But it is always advisable to have one to get the correct guidance and to present your case better. Otherwise, RPs on their case can go anything. Even lawyers represent themselves in some of the cases. Then they just remove their band and appear in the court. So if you see in some of those YouTube videos, the lawyers are appearing but without the band. That signifies that they are appearing in their personal case, maybe it matrimonial or something else. So that's what the convention is. Now, it's how the lawyer get their authority to appear in a particular case. So all of you must have seen the wakalatnamas. Those are the typical document by virtue of which a lawyer gets the authority to appear in a case. There are multiple provisions in the CPC which deals with the conduct of the lawyer, how he can be engaged, what concessions he can give when a fresh wakalatnama is required. In fact, there is a provision which says that once it has been there, it can go to the higher courts and then there is no need for wakalatnama. But typically convention is that whenever you file a fresh case in any higher forum, the registry will ask you the fresh wakalatnama. So what if you don't know the client? Or what recently there was a case where the advocates were pulled up because the client refused to say that they did not sign the document. So in order to verify the sign, the court system is built-in mechanism of notarization, where the notary identifies the person before you take the wakalatnama. This provision is helpful. Even when the RP has doubt on any of the signatures, he can protect himself by getting that particular document notarized, because the notary takes on the responsibility to attest that this particular signature belongs to that person. So there are multiple, many Supreme Court judgments which are on the wakalatnama. It has to be properly verified. At least it should be signed by the client. That is one of the most basic requirement. And the client has to mention in what capacity he is signing. So if suppose it is for a company, it has to be accompanied with the proper board resolution, etc., or a power of attorney, etc., just to sign that thing. Because this is the document by which the advocate gets his right to appear in that particular case. So this has to be proper in all respects. So Udit pointed out one issue, like change of the resolution professional or giving up the brief. So RP as well as the lawyer can be changed at the whims and the fancies of the client. So there was some kind of similarity, but some kind of distinctions. Few of the RPs in way back tried to challenge their non-appointment or removal before the NCLT on the ground that no reason has been assigned for their removal. And therefore that removal is bad. So the NCLT, it was upheld, I think, to the topmost court, that there is no requirement of assigning a reason to change the RP by the COC. In similar manner, as a lawyer, and client must not give any reason to change the lawyer. It's a thing of trust. As soon as there is a lack of trust, they have the right to change. So this is something which is a similarity between the two things. One must bear in mind that it's the pleasure or rather will of the client rather than the monetary value associated with it is not paramount. The paramount is the interest of the client. All the lawyers are supposed to file the wakalatnama except the government pleaders. So by any chance, if anybody is a government pleader or come across where only memorandum is filed, then the government pleaders can Just file the memorandum of appearances and that would be fine. There will be no need of wakalatnama for the government leaders. So, if a counsel wants to leave the brief for any reason whatsoever, then as per the CPC, he must move a proper application before the court to seek recusal and give the proper reason for it. Irrespective of the fact that whether the client has paid fee or not. A lawyer never has the lian over the brief that since my fee has not been paid, I will not return the papers. That could not be the case. Similarly, an IP can't refuse to share the document merely because they have not been paid to the fees. If the fee has not been paid, it will ultimately become the part of the larger pool which will be dispersed according to Section 53. But that's not a valid ground to hold any of the documents in the insolvency. So there is somewhat similarity. One must bear in the mind. So how this entire system runs, when somebody wants to change a lawyer, the practice or the convention which has been developed in most of the court that the prior counsel gives the NOC. Normally it is given on the same wakalatnama and therefore it translates and anybody can change. Whether a lawyer can file a writ petition because there is no effective remedy or IP can file a writ petition to ask his fee, not very tenable idea because I have appeared in the few of the cases on the behalf of the IPs. Normally, the judiciary feels that the fee of the IP is like a fee of a lawyer. It may or they don't look very favorably when it comes to the fee part, particularly the judges, which feels that sometimes it might happen that they should not focus on the fee rather than they should focus on the work. That's because of the perception gap, which Udit explained very carefully. No lawyer, whether he has been paid fee or not, can refuse to appear on the ground that he has not been paid the fee. Some of these cases reach to the High Court and maybe in the Supreme Court, but a lawyer cannot refuse to appear because he has not been paid fee. That's something which is not envisaged. So the case of the RP is also something similar. Unless he is removed by the COC or the NCLT or whatever may be the reason he is supposed to perform his duties. So fee is not a prime criteria when it comes to both the professions. If somebody doesn't appear as a lawyer, the matter becomes ex parte and they are adversely affected. If the RP doesn't perform his duties, their interests are adversely affected. Both can be held accountable for such a conduct, be it RP or be it a lawyer. Further, if by any chance any of you had seen that there are rampant strikes, fortunately in NCLT no, but if you go to the lower forums with lower judicial forums or not lower but district judicial forums, they are all the same. There is strike or very flimsy ground. There are arrangements for it, but if somebody is not appearing, then they take the risk. And that is not a valid ground as per the law, but in practice, it turns out to be very difficult to appear in any court when there is a strike or something. Then concessions or decision making. A lawyer cannot take any decision on the behalf of the client without taking his consent. But an RP takes many decisions, which is his responsibility as an RP, and for which he doesn't require the approval of the COC, either before and after. So those are the distinctions. So one must be conscious that who is looking after constantly or his duties. Like we have completed 2 hours, and I think some of the people are still there. It means that some people are getting some value out of the discussion. Thank you very much. Any of you have any questions so far?
Hello.
Yes, Anjit.
Actually, I have one submission.
Yes, sir.
The first thing is that most of I face this that due to some lawyer was not aware about the provision of IBC, and they represent us. So sometimes due to their fault, we suffer, we the IP suffer. So what is the solution for that?
Yes, so that's a very pertinent question. Actually, there is a business dynamics which is playing here. So the insolvency itself, sometimes the COC doesn't pay the enough. So the RP hires the most economical options.
But that is not right.
Let me complete my answer.
Okay.
I'll come back to one of the most economical options. Or the options like they choose, they don't have enough time to devote on that particular brief for whatever reason. Either of that reason, what happens is that the RP feels that he has not been represented properly, or the answers which have been posed by the judges is not answered properly. So the old advice, which is the gold, whenever there is a case, you must be there to support your counsel. If there are any, so the nature of practice is such that no lawyer can survive on one brief. Most of the lawyers have multiple briefs in a day, which they propose a day earlier or 2 days earlier. Sometimes their recollection is perfect, sometimes their recollection is not. You must know that they are also a human being, okay? And their memory is bound to fail them. And sometimes they might not be quick on their feet, like they can't think instantaneously and give the most clever answer which might be coming in your mind. So two things, there has to be a continuous channel of communication between an RP and their counsel. There has to be a proper briefing before every hearing, because even if you have given him 1,000 papers, he might not be able to read it, recollect it. So suppose tomorrow there is a hearing, the best way, since you have asked, I'm thankful for that question, because that will help many of the people if they adopt these practices. Though at least there has to be a short briefing to the lawyer a day prior, because whatever he hears from you, the chances of his getting recollected that data or that information is very high on the next date. 1. 2. In the discussion, you must think that what is the issue which is coming before the court on the next day. So that will give you an idea what questions the judge might pose and what are the relevant facts which are required to answer those questions. That exercise has to be repeated every time when the hearing comes. If you feel that I have briefed him 1 month back, the matter is coming again, he is supposed to know. It doesn't happen that way. They fall ill, they are not able to get the time. Sometimes they are like simply for some reason they are not able to attend the file. So one practical tip, have a briefing, howsoever long or small, a day prior. The chances of recollection is really high. The next thing, if it is possible, always go in the court along with the lawyer. So sometimes a question is posed, judge in a particular manner, and the lawyer is understanding in a different manner. Okay, there is a communication between the two and you are able to identify, then you can point out to the lawyer.
So can I intervene? Can I intervene the lawyer between the arguments?
Very good question, sir. The answer to it, normally the NCLT will allow you to intervene if there is a factual question. NCLT also in sometimes allow. Only in the Supreme Court and High Court, they will say that instead of telling directly to the court, you say to your lawyer and he will answer the question. But no court will ever refuse you to communicate with your lawyer to say that don't communicate this.
Because practically, you see, sometimes if you hire a senior lawyer, so normally they don't follow your whatever your direction. They do according to their thought process.
Okay.
Most of cases, I feel that.
Yes. So
and if the IP suffer for that, if anything wrong, they have submission. Mostly we the IP suffer. We don't have any option to deny that. No, it's not my direction. Like this.
Okay.
So this is main point.
Yes. Thanks for that question. That's another thing. That's different than the previous question. It's when you hire a senior or an arguing counsel.
Yes.
Okay? So in the pyramid of the decision making, the amount of knowledge gets reduced at each level. I tell you how. A client who has lived the case or an RP who is running day to day the company, he knows the most. Nobody else more than him. That's the fact. When this knowledge is transferred from the IP to a lawyer, he knows maybe 50% or 40% of the brief. Okay, he doesn't know it fully. Okay, that's the hard reality. But since he has the time and the skills and he's doing it repeatedly, you appoint him to represent your case. So he identifies the key points which he thinks that it's likely to come from the bench, and he tells it. When it comes to the senior advocate and arguing counsels, the law says the few of the things which many of the people who are not regular practitioners are not aware. Senior advocates are not supposed or ideally supposed to be in direct liaison with the client. They are there because of their experience, knowledge of law. So the court designated that you are fit enough to help us on the questions of law. Okay, because of your experience or whatever reason. So most of the times the client hires the senior advocates in every hire forum because they feel that even 1% of the eloquence or experience can make a difference to their case. So suppose for a counsel you are paying X amount, you pay 10x to the senior lawyer even for one hearing. Okay, but the amount of time a senior advocate can devote on a brief is very limited. Sometimes they have a briefing of 1 hour, 2 hours. So out of that 40% which you have transferred your knowledge from yourself to the lawyer, only 10% gets transferred to the senior advocate. Now, the real challenge starts when the judge comes up with an unexpected questions, okay, or the line of argument. Because it is a subjective subject, the entire system is manned by human beings. It's prone to errors. So what happens is that sometimes those questions are not properly answered. Sometimes they are not answered as per the wishes of the client. The best way to deal with such situation, there is no 100% foolproof solution. But the best way to deal with the situation to actively participate in the briefings when the senior advocates are being briefed on the matter. And since the matter are high and you are paying such a huge amount for just one hearing for that senior advocate to be there, be present in the court. And if you feel that something is going here and there, then request for a next date. Because if you lost the battle, there is no other day to fight. In Supreme Court, if you lost the battle, there is no other day to fight. Okay. So if the calamity is going to come on, say, today, it's better to have it deferred for the next day. There is no harm in it. There is nothing wrong at it. Sometimes the people say that the advocates take date, etc., etc. But there is a practical difficulty. Sometimes they don't have the answer. Okay. So if you are presented with a book where you don't have the answer, it's better to save that date. So that's a practical solution. There is no legal answer to that he has not advanced an argument. If a senior lawyer is never supposed to advance an argument in factual which is incorrect, or a lawyer, That's absolutely no. But if in law, he takes a particular interpretation which you don't feel right, it's a very gray area.
Right.
So your communication to the senior advocate must be real clear. We want to stick with that particular point. Sometimes I'll give you an example. If you go to a particular court and the court says you have done something wrong, you don't expect it, okay? And the court suddenly start very furiously. You haven't done this thing wrong. If you go with, I will impose penalties on you, okay? They start with that kind of thing. And sometimes the lawyer says, my lord, let me take the instructions. So that's the way he is trying to avoid the catastrophe. The second thing white might happen, they ask you to change a particular pleading or give concessions. Okay. So no lawyer can give concession unless it has been instructed from the client. So you can always say, let it be. At that point of time,
how can IP avoid himself that the burden on the advocates that he did some wrong and the IP suffers? How can IP avoid this?
See, that's
IP defends himself that this is not the direction given to the advocates. In fact,
see, so there are two components. I'll tell you, lawyers only do two things. In a larger amount of one line description, the single description is a lawyer goes by the instruction of the client. He is the medium of the communication. There are only two ways of communicating. One is writing, one is speaking. If you see the writing, everything goes under your signature, so there cannot go anything wrong. If you haven't read, that's your fault, not lawyer's fault. Sometimes the client doesn't read at all, also bheja hai to kar do. That should not be. You are supposed to read each and every word on which you are putting your signature. The second is the oral argument. The oral argument again have only two components, facts and law. Okay. He cannot speak any fact which is factually incorrect. You are duty bound to tell him that factually this is incorrect. This is the correct way. You can point out even in the middle of the argument, please correct the facts, and he will do it. 100% of the lawyers will do it. Okay. As far as the law is concerned, even if suppose he is not able to articulate well, you must try to save the date, and after the date, at least you give him a written notion to it. This is the line of argument which we want to take. Most of the time, mistakes happen when there is a communication gap between the client and the lawyer. Okay, I think that is a practical solution, may not be ideal one.
Very great answer. Thanks a lot. Very great answer. Thanks a lot.
Thank you, Ranjit.
Can I submit something?
Yes, Harshji, most welcome.
Yes. Sir, you mentioned during the course of this talk that if I want to change a lawyer and his fees has not been paid, he cannot refuse to hand over the documents. Right, sir?
Right.
But I am facing a situation practically. There was a lawyer who was engaged by the previous RP. Now this lawyer is refusing to hand over the documents. He says that first pay my fees, then I will hand over the documents to you. And the new lawyer whom I want to engage, he said that till the time I get an NOC from the previous one, I am not going to take up your matter. No, what should we do in this situation? Very difficult situation for me, actually.
Sir, straightforward.
This is a real example. This is a real case which is happening with me.
Straightforward answer to your first question. A lawyer cannot hold the documents merely because he has not been paid the fee. That's the law settled by the Supreme Court. That amounts to a misconduct.
Right, sir.
2. By the time you reach to the Supreme Court, that's a lot of delay. So there is a practical solution to this problem. Being, if you are an RP in that particular case, you apply for copies of all the documents and you will get it from the NCLT. Okay. And then you appoint a new lawyer. With the if the earlier lawyer has not given the NOC, you can ask the new lawyer to move a proper application. He will move a proper application.
Before NCLT?
Before NCLT. If he comes and objects.
NCLT is not a body for this thing. They say that it is a civil matter.
No, see,
you make a complaint to the Bar Council.
No, we both are talking different issues. If you want to take the action against your earlier lawyer, then they are absolutely right that you are supposed to approach the Bar Council. Okay, that's 100% is correct. That's a misconduct. Even NCLT is right, and you are also right that that's not a proper way. I'm coming to the solution of your problem. One, you apply for the copies, you will get all the documents filed before the court.
Fine.
Okay. Because NCLT, the registry it's an online filing that doesn't insist on the NOC. Like I have filed several times. There is no, if he comes and raise an objection, then your lawyer will be properly equipped to defend it. Okay. I'm not sure in which NCLT you have a case. Delhi, there is no problem such. They never, the NOC is not required. The fresh wakalatnama gets filed like this.
The new lawyer is refusing to accept the assignment till the time he gets an NOC from the previous one. He says, no, I can't enter into this sort of issues tomorrow later on.
You have to think on your choices.
Someone may make a complaint against me that you have accepted the assignment without taking NOC from the previous one. So I don't want to enter into these sort of things. The new law says.
I think, Malab, you have to consult multiple lawyers. There is a way out for it. Okay. If you stick to one, then he is not doing, then that's a different issue.
Nice solution. It's a good solution.
Because what happens is that the people write an email to the other side demanding the NOC. If there is no reply, normally the wakalatnama is being filed. And NCLT never refuses to take on valal. So take an example. I am practicing in the Supreme Court. Okay. I am an advocate on record in the Supreme Court.
Yes, sir.
There are multiple times it happens that the people are not satisfied with lawyer and they want to change it.
Yes, sir.
And it never ever happens in my office or with me, either way, where an advocate has refused to give NOC in Delhi. There are very few who...
But there are different kinds of people, different kinds of lawyers. So yes, everyone is not like you. Everyone is not like you.
So you have to find a creative solution and you will get it.
I tried a lot, but the new lawyer says, no, first get me the NOC from the previous one, and the amount is huge, which is outstanding against him. And there is no money in the company.
It's very difficult if you don't have any special interest in that particular lawyer, at least take a second opinion and somebody will be ready to do it.
Oh, okay, sir. Thank you, sir.
Thank you. Thanks for your question, Harshji.
No, sir. Welcome to respond.
Yeah. So, any other question?
Nice.
Okay. So, I assume that most of you people, your queries got satisfied till this end. So, I'll continue this monologue for 10-15 minutes more, if it is okay with you. And then I'll open the session for all the questions for whoever has the questions. And I try to finish it 15 minutes before the time, so all of you can have your dinner or the evening walk on time. So actually, I'll do one thing, Harshji, for your benefit. Like normally after all these presentations, the institute says that you must circulate the literature on which the presentation was given. Okay. So I will forward that mail. Okay. And there will be a document. This document is prepared by a former session judge. Way back. I think it's 2015. Yeah, it's 2015. I can just see it. Okay. Its title is Role of Advocates in Judiciary. Okay. So you will get all your answers regarding this along
I will look forward to that document.
Yes. Just a second. Sanjay. So
at your convenience, no problem. So I'll look forward to that.
So उठा ले. Yes, sorry. So there was a
I am
phone
sure
call
this
which was
document
Maybe.
this document will be of
Yes.
lot of help to us. But
Yes,
the
sir.
way you have explained the practical things, very admirable, very nice.
Yes, sir.
Thank you, sir.
Thank you, sir. So the beauty of this document is, it is one of the most comprehensive document which you can find on the internet on the conduct of the lawyer.
ठीक है, sir.
Many of the lawyers may not be happy with the things, but you will get all these answers with the case law and sections.
Great. Thank you.
Okay. But use it judiciously, like not on everything you are supposed to.
No, of course, understand.
And the unfortunate or fortunate thing, whatever it may be, it's very difficult to prosecute the cases in the Bar Council.
You're right.
And the reason is historical. Historical in the sense that even during the independence movement, and as a lawyer, you are supposed to defend many people who are very powerful in one way or another, okay, which may try to harm the lawyers physically, financially.
Possible.
So the safeguards which is placed on the lawyers is way higher. It's very easy. Suppose if you are defending somebody who has done some crime, white collar or any other crime, to jeopardize if he feels that he might come against the lawyers. Similarly, political vendetta is also one of
of course, everything is possible.
Everything is possible. So the sword which is hanging on the neck of an IP of IBBI is far more sharper and exercised repeatedly than in a case of
exactly. You're right.
ठीक है ना sir? So yes, so that's the there cannot be any compromise without the consent of the clients. So there are multiple case laws on these issues.
Of course.
Then the advocate cannot prosecute in his own name. And this particular thing is somewhat relevant in the NARA cases as well. So there is a, if somebody scans the transfer of property carefully, even that time, like the Transfer of Property Act is really old one, even at that point of time, only person who has been debarred from buying an actionable claim is lawyers. Okay, so there is a specific provision in the transfer of property which prohibits lawyers from buying actionable claims, because then they become the party to the less, and that layer get removed, which we have discussed earlier. And that's why they can't, they take an example, they can't take a recovery cases and say that I'll take a contingency, or they can't become part of that recovery in any manner whatsoever. That's a complete prohibition. Another concept is like notice to a party, notice to lawyer is one and the same thing. Either the communication has been addressed to a party or a lawyer, it will be equally counted. If there are no instruction from the client, even then the counsel is supposed to go and in fact have to produce the proper document before the court to get his recusal or whatever it may be. So he wants to not to fight a case, then proper reasoning. Normally, by convention, if there is no NOC which has been given by the client or client has not taken the fee, then there has to be a proper application by the counsel to withdraw his name from the court case. It's not that simply he can, if he says not come, I will not appear. That's not the way the system is designed for. Being an officer of the court, a lawyer is supposed to be present in the court when the case is called up. When he is not there, the easy solution is to take a passover and adjournment. Now it has become comparatively easy with the e-courts and everything. In criminal cases, being represented by a counsel of your choice, or at least by a counsel, is a matter of fundamental right. not very relevant for the IBC, but that's what brings out the distinction between an IP and a legal profession. That's something which has been so fundamental that it has been protected by the Constitution. A lawyer is not supposed to make absent deliberately. That's what something like as per the law is. And if we go into the small duties, there are many of them. So in sum and substance, coming back to the original title of the discussion, IP as an advocate or advocate as an IP, I'll just try to summarize the entire discussion in few points. The role of lawyer is very limited. The role of IP is very exhaustive. In case of a lawyer, there is a complete chain of system which doesn't have a conflict of interest. But in the IP's case, there is some kind of conflict of interest, because of which the fee becomes a troublesome part. It's always advisable to have a lawyer to represent yourself, because the tree should not eat its own fruit or something like there are some kahavat or something like that. So, or doctor himself doesn't treat his own illness. So it's something, it is always advisable to have something which gives you a protection and able to tell you the drawbacks of your case. One of the key thing is the lawyer always tell to the court what you say, but in the discussion he will be able to tell you that what you think might not be the correct way. So it happens with several times with us, or even when we go to brief the senior advocates, that what your perception is incorrect, and even the perception of the Supreme Court is not always correct. So that's why you see the reversal of the judgments up to the level of the Supreme Court, and Supreme Court, it also overturns its own earlier judgments, because the law is a subjective subject. It's never an absolute. In this present system, time guarantees cannot be given. It's impossible in any manner whatsoever. So those are the broad I can say broad ideas which I have discussed so far. And if any of you have any questions, you are most welcome to ask. So if there are 5-10 questions, I will be really happy. And otherwise, I will request, whenever the questions khatam, I immediately will request ICSI to release me and all of you for your evening walks or dinners and etc. And I'm really thankful to the people who have been participating actively. You have been a wonderful audience, actively participated, and few of them kept camera. I will really appreciate if somebody can ask few more questions. Umeshji, you have any questions? Questions, comments, any experience sharing? Sir, please switch on your mic. Your microphone is off, sir, for some reason. It's showing off. Okay, there is some problem.
Yes, sir. By the time Umesh ji speaks something, I would like to appreciate your presentation. I mean, I was thinking as if I'm in the court only and practically seeing the situation which is being handled and the preparation at the office and the communication with the advocate and the presentations. Like layer you explained very well, this has to be there. Because if I go and stand there, I may be having the technical facts, I may be having the technical details of the case study which we have done, KIRP or anything. But the presentation is again a very crucial part, which an advocate only can do so well. This is what I feel, and you have really shown the right side of it, why it should be there and how it should be there. That's wonderful, sir. Your deliberation is, you're so patient, you are telling the things so nicely and calmly. That's very nice, sir. Very nice. Congratulations to you also for giving such a nice deliberation, sir.
Thank you, sir. Thank you,
Thank
sir.
you very much. Thank you very much.
Sir, I'm Satya Devi, Company
Yes, ma'am.
Secretary, Insolvency Professional.
Yeah.
In saying that advocates should represent, I also agree to some extent because we need more exposure for facing the courts. But sometimes, our presence is becoming very useful for because the advocate representing knows only certain factors and not all the factors. So we feel we are wasting a lot of time by having an advocate also. They are also present and we also should be present. And courts are insisting that we also should be present for many of the matters.
Yeah, that's
So we are
something.
finding it very difficult. When they are there, we don't want to go. But we are not able to avoid and it is a waste of time. And sometimes I feel being present is very useful for us to represent, to know and to represent other factors which the concerned advocate may not be aware of.
Yes, thank you very much. And it's always advisable, as you have said. And the thing which you have pointed out is a really cause of concern. So in all civil proceedings, the presence of the client is not required unless he is coming to give an evidence. IBC is by its very nature is a kind of a civil case. But some of the benches, which some of might have the chances to appear, they are insisting on the presence of the RP all the time, even if it is not required. That's the cause of concern. But that also has a kind of hangover because sometimes or a good number of times the advocate is not putting the correct picture or giving them the answers correctly.
That is true. So we are finding it very useful if we are present. I feel I am comfortable if I am present. I know what is going on. Second thing is that the login is not looped to us. Whatever the advocate is filing, unless he gives that to us, we are not able to have a track of that. So in many of my cases, where it is prolonged for 3 to 4 years, I don't have the proper papers with me. I'm not able to number that number. This doesn't tally because we are not looped in into that login. So I prefer that NCLT login should loop the concerned RP or liquidator whenever an advocate files the papers, automatically looping. I prefer
that should happen, but even like whenever there is no login, the best practices is at the time when you are signing the document, keep a copy with you and put it in a proper folder.
We are scanning and we are keeping.
Yes.
But see, advocates insist on that being given without numbering, index, everything. So we don't have the page number when we are talking. I'm finding it very difficult to relate with the page numbers. And with 2019 cases and all, later on we included. Therefore, looping is better, I feel, along with the advocate, with the concerned professional.
Yes, that's a suggestion, but there is one more thing you can do, because invariably, all the pleadings which is filed before the NCLT, it is mandatory to serve the other party. Okay. In all those services, the page numbering and indexing is going properly because other counsel you can't do it. So what you can do as a practical suggestion, if I have to you, is once you sign the document, the advocate might be doing the numbering and indexing after the document is signed, but it is always when he is serving to the other side, the indexing and numbering is going. So request your advocate to put you in the CC, and thereby you will get the correct numbering and the pagination along with the index. So you will not face that difficulty. If you have the login, well and good. Even if you don't have a login, suppose you are advising in some manner which you are not an RP, okay, and you still want to have those indexing and pagination, you have a right to have so. So take the document when it is being served on the other side, and you will get that solution. And thanks for your question. Anything else, ma'am?
Nothing else. We are only advocating for presence of advocates. We should talk for us also. I'm practicing both as professional and as advocate. But you are saying only advocate should be present for the children. How about how will we go ahead? Get expertise in that field.
See, if
Anyway,
you
we are not allowed to the courts.
if you want to cook the food or make the best example is the Indian food. Okay, suppose if you want to make a chapati or a rasam, the way to learn it to do it. So the more you do, the more experienced you will become, and might be you will be better. You will be a better profession in as an advocate than as an RP or something else, or you will excel in both. So do it repeatedly. It's an acquired art. Nobody is born like that, and by practice you can learn it. The people
Anything can be learned. That is true.
Any question, Pankaj ji?
I think these are fine. So basically, you can also seek a copy when it is filed. Write a specific email to the concerned lawyer to provide you the copy of the relevant document.
True, that is true. See,
those records may be required for filing with the IBBI or so, the details of the case. So therefore, the copies may be asked for. And
it is not the recent cases. Sorry to interrupt. It is not the recent cases filed before there is a portal, online portal. So all filed manually long back and still going on, cases going on, huge volumes. That I'm finding it a little difficult to manage.
I think there are two scenarios. One, the IP can file the relevant documents from his login ID as well. So in some context, for example, you can share the email, the login ID with your concerned lawyer, and all those things, filings are done through your login ID created on the NCLT portal. This is one way. The second way is if the lawyer files it from his ID, then you may seek a copy of the document actually filed, the notarized document, the index document, which is filed with the NCLT. Those copies can be sought. So therefore, you would have the correct and indexed and paginated documents which is being filed, so which can be easily referred to and will be very easy for you.
Yes, thank you.
Thank you, Pankaj ji, for your participation in the discussion. And
I think this is a very good session you had. Many thanks to you.
Thank you. Thank you. Any other question? Prabhu Dayal ji, Suhas ji, Harsh ji, and all other questions which are like participant who is like
Supreme Court is taking a lot of time, sir, to dispose of the cases. There is an appeal filed in 2021. I had to get my fee for that, and it is hanging with the Supreme Court. NCLAT decided that the cost should be borne by the corporate applicant. He had gone for an appeal to Supreme Court. From 21 till 24, nothing, not even a single paisa has reached me.
There is no solution to it with no one.
Supreme Court is taking a very long time.
Every court is taking a long time. I'll say the incident of today. Today, like I was appearing in one of the cases in Delhi High Court. Prior to me, there was an advocate who requested for a short date because nowadays the dates are given in 2025 in Delhi High Court. Okay, in some of the cases, like most of the cases, it's 2025. Sometimes it's going March, April, May, June. Okay, so an advocate asks, sir, the guy is very old. Okay, etc., etc. So the judge says, Mr. Counsel, your case is only 5 years old. The case before you was pending since 1981. What can I do? I don't have time.
But that is the problem. See, when we are filing some court, some writ petitions in civil courts, we are not able to dissolve the corporate return. And we are answerable to NCLT for the delay. And all matters cannot be assigned. And many of the decisions could be taken only depending on the clearance of the writ petition by the employee, or we are going for settlement. How about withdrawal, sir? Withdrawal when an employee is filing a writ petition in High Court and he wants to withdraw. What is the, he has to go only through his advocate, or he can go personally and file amendment?
He can go and personally withdraw.
Possible?
Yes.
How about the advocate who is on record?
He can also go.
No, he
can.
is not allowing. He is not, in fact, allowing for the withdrawal. He's telling you have a merit in the case, you will get it, he's saying.
No, that's his opinion, but he can't refuse.
No, so
That
he
is what I
can't
want to know.
dictate. I will say that he can't dictate the terms which the client prefers. It is ultimately your petition which is before the honorable court. So if you think that, aside of the advice of the lawyer, if you feel the client feels that he wants to withdraw, then he can. On the relevant date.
I think that the client, I think that client is trying to be politically correct on both the ends. Because normally as a lawyer, if some client says that I have to withdraw the case and this is the instruction, the first thing is go and withdraw. That's it. No question asked. But he is saying that it's a good case, so he should not withdraw. So client is going politically correct that he.
Sir, I spoke to the advocate. I didn't want to go for confrontation with the employee advocate. He is not my advocate. He is telling, who are you to decide on this? It is the High Court who should decide on the claim. We are not the person to decide this claim. Then I didn't want to go for an argument with him.
No, there is no, that's a great step you have taken. No need to argue with him. But the client can always withdraw. He can always appear in the court and say that I wish to withdraw and the court will allow it. Because even if suppose I wish to withdraw as an advocate, then I always take an instruction invariably in all cases in some form of writing from the client that he wished to withdraw. Once I get the instruction, I'll just withdraw it. That's the normal practice with all the lawyers, at least in Delhi.
Absolutely for withdrawal, because that step cannot be taken by the lawyer because something may fall later on upon the lawyer. How had you withdrawn? Suppose the client can come the next day. How had you withdrawn without my written instructions?
Right.
So that anomaly is generally the no lawyer prefers to withdraw on an oral request. He will seek some documentary thing, even a text message or something written. And sometimes
I think some technical error. Now Pankaj
entered into a settlement agreement. In that they have agreed to withdraw their petition filed with the Madras High Court.
I think that the document which I will send you, the role of advocates in the judiciary, you just go through it. The answer is there with supporting case laws. Okay, so you can show it to the.
I need one more clarification, sir, please, sir. Sir, there was a there was an execution petition which was ordered by Pondicherry Court, Magistrate Court, Judicial ADJ to Pondicherry.
Right.
Then during liquidation, so we tried our best to set aside it. We could not do it at Pondicherry. Not do that. Therefore, they garnishing order during liquidation. We got a stay in the Madras High Court, and that is pending. Now, this writ petition, due to this settlement agreement, they agreed to withdraw the writ petition that was ordered by the ADJ 2. In that, it is mentioned that writ petition is closed. That is fine, sir. See?
Yeah, it's fine.
Fine.
The writ petition is closed in the High Court's order, no?
No. Writ petition is closed in the Pondicherry Court. Appeal, I only file. No, I can always withdraw it.
Okay, you filed an appeal and you have withdrawn it.
No, I am yet to withdraw it because their order, it is an order, it is an application filed by a section of the workers before the Pondicherry Court. So I filed an appeal against that. So I wanted them to withdraw the EP petition in the labor court first. So that they have done. In that it is said EP is closed. That is fine for me to go for withdrawal.
Yes.
Because I was told by my advocate, he is suggesting it is only said that EP is closed. Therefore, if you withdraw the appeal, it means you are lifting the injunction, and that stay will go off and the petition will survive his telling. So petition is closed, that is enough, no?
No, my personal opinion, without going into the documents, normally the labor courts order are not best worded. When they say close, means it has put an end to all kinds of things which is going before the court. It is good enough a withdrawal. Okay. But in case you have a doubt, you consult the local advocate. He can always seek a clarification application. But to my understanding,
send the application, that application, petitioner application, and as a respondent, my counter for that. send it to him. But initially he said like that. So I was little worried as to how I should go about.
No, if there is a doubt, you can obtain a clarification, but sometimes the right people, like I have seen those closed orders.
Okay.
Okay, so that they put an end to those proceedings.
That is correct only. That wording is correct.
No, that's not happily worded. Either you should write it specifically, okay, but they serve the purpose. But it's always, if you have a doubt, it's better to get a clarification. So thank you very much. And thanks to all of you. You have been a wonderful listeners. And this is one of the most participative sessions so far in last few sessions. And if you have any questions, you are free to come back. I will circulate 2-3 documents after this to the institute, and you can get copies of that. And all of you are welcome to my office to have a tea, coffee, or any questions you have.
Sir, we would request ICSI to give your mobile number also along with the
yes,
document
sir. Yes, sir.
you are going to share, so that you can be of help to us in future for the real guidance, sir.
Email address, mobile number, and other addresses.
I think I will do one thing. There is some option of chat.
Chat में provide करा दीजिए.
So I'll put it in the chat. So okay, there are some raised hands on some questions. Okay, where is the chat? Chat 16 chats. So most of the people have given their enrollment numbers, so the presence is fine. I'll put it in the chat box, and it will come along with my email as well.
Right, sir.
Okay, sir. Otherwise, my email is very simple. mail@Manish Paliwal. Manish Paliwal is my name. .com.
Manish Paliwal.
mail@manishpaliwal.com. So I will put it in the chat box. It's easy to recollect. I think mail@manishpaliwal.com.
Right, sir.
Thanks.
Thank you. And I'll request the administrator to please close the session.
Another word for IP, the administrator.
I think there is no one. Just. Is there anyone from the institute? It seems that
they have become. Yes, sir, they have left. No issue.
No issue. So thank you again, everyone, and you can log in, and I'll wait for them. Thanks. Sir.
Thank you very much, sir. I would like to thank you from the ICSI group people, sir. Very nice.
Thank you, sir.
Yes.
Hello,
sir.
मैम वो कोई सेशन क्लोज करने के लिए बोल दीजिए किसी को. अच्छा, आ गए हैं.
Okay, sir. Thank you for the session, and thank you for your insight and knowledge to make this session so interactive and fun. Thank you, sir.
Thank you very much.